Supreme Court of Canada, Canadian Imperial Bank of Commerce versus Langlois. The reason for this case: bills of exchange, promissory note, purpose for finance of mobile home, not marked consumer purchase, note void. The defendants bought a mobile home from Pacific Mobilex Limited. Its salesman introduced them to the consumer loan officer at one of the plaintiff's branches, who drew up a promissory note which was not marked consumer purchase. It was signed by the defendant, husband, and guaranteed by the defendant, wife. The proceeds were paid to Pacific Mobilex, which went out of business before the defendants were able to obtain delivery. On the question of whether the note was void under Section 190.2 because it was not marked consumer purchase, held, it was void and the plaintiff's actions were dismissed. The transaction was a consumer purchase and therefore the note was a consumer note, as defined in Section 189.2. In the present matter, however, this is the judge speaking, I am satisfied on the evidence that the promissory note given by the defendants to the plaintiff was issued in respect of a consumer purchase and accordingly is a consumer note as defined in Section 189.2 of the Bills of Exchange Act. And I am fortified in this conclusion by the fact that the plaintiff was well aware of the nature of the transaction which was handled by the plaintiff's consumer loan officer. Further, the defendant received a letter from the plaintiff's consumer loan department welcoming him as a consumer loan customer and signed by an assistant consumer loan officer. Having considered the evidence, I have no hesitation in making a finding that the transaction in this case was a consumer purchase, that the promissory note was a consumer note, and that the words consumer purchase were not marked on the face of the consumer note. It follows that the consumer note is void. Under these circumstances, it is not necessary to consider the provisions of 189.3. The plaintiff's action is therefore dismissed with costs. So what you just saw there was a judgment that is coming out of the Supreme Court of Canada. This is a judgment that dates back to 1974. So that means somebody in 1974 figured all this out also. They figured out the credit system and they were able to free themselves from the situation. Now the Supreme Court of Canada is a higher court than any other court that is presently here in Canada. It's higher than the superior courts of your province. It's higher than the federal court of Canada. Now in this Supreme Court judgment that you saw, the judge states that a consumer note or consumer loan, it must be marked consumer purchase. And if this consumer loan or consumer note is not marked consumer purchase, the courts, as you see, the Supreme Court of Canada will void. They will void the contract on your behalf. And you will not be stuck having to pay this money that was created out of thin air. If you want to have the information and the understanding concerning what's transpiring with consumer contracts and credit contracts, go to eternallyaware.com and go to the take-home page videos and go onto consumer notes. Consumer notes. There, for a modest price, you're going to get explained to you exactly what's going on here in Canada. You're going to be shown the jurisprudence concerning the court systems and how to free you and your family concerning the debt that has impacted your lives. Because you don't have to carry this debt. These contracts that they're using against us are fraudulent. They are falsely filled out, and therefore there's no obligation upon you. If you understand and take the time to study and know the information and then apply what you will learn, you can have the same exact results as you see in this jurisprudence or this case judgment here, where your consumer note will be voided, should be voided, and that obligation will fall aside. Because once you understand, there really is no obligation. The money that they claimed they have lent you was nothing more than an artificially created account.